Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today I have two guests with me, Naomi Cahn, who's the Justice Anthony Kennedy Distinguished Professor of Law, and Armistead Dobie Professor of Law, also co-director of the Family Law Center, all at the University of Virginia School of Law, as well as Alyssa DiRusso, the Whelan W. and Rosalie T. Palmer Professor of Law at Cumberland School of Law. So thank you both for joining us.
Good to talk to you. Great to be here. Thank you.
Well, it's fun to have you both on because you are veterans of prior podcast episodes. This should come this should be like second nature to you to be on the podcast today. But we are missing one of your co-authors, Susan Gary, Professor Emerita at the University of Oregon School of Law, who I hear is doing something really much more fun.
She is. She's teaching an estate planning related course in Hong Kong this semester. Based there, and I think it's maybe 12 or 13 hours ahead of where we are now.
That's terrific. Well, it's good that she doesn't have to be worrying about time change to join us. But I'm looking forward to talking about your book. So you all have just had the second edition published in early 2025 of Wills, Trusts, and Estates in Focus. And were all three of you the co-authors on the first edition as well?
That's right.
So tell me how you came to find each other to write this book and what prompted you to write the first edition. And then we'll talk about how the second edition is different.
I should say that Susan and I have worked on another Trust and Estates casebook together. So the two of us have many years of working together. But Alyssa, do you want to take it up from there?
Sure. And Naomi and I got a chance to work together on an ABA book before this. So we had a chance to work together as well. And I think we're very fortunate in that the Trust and Estates community is very small and collaborative. And if you stay in it for long enough, you just wind up crossing paths a number of times. And we're both all three of us, heavily involved with the Association of American Law Schools. So it's people at AALS, as well as ACTEC, American College of Trust and Estate Counsel. So we had a lot of overlap there. So we just appear in the corner of each other's world an awful lot. So I think that collaborating on writing together naturally grows from you coming across each other in these communities where we exchange scholarship and talk to each other about what's been important to us in the field.
And so when we were asked by Aspen to develop a different type of casebook, Susan and I immediately turned to Alyssa and said, might you be interested in joining us on working on this different approach to trusts and estates? And so that's how the three of us started to work together. But yes, as Alyssa said, the trust and estates world is a wonderful community, and we do get to know each other through overlap. Alyssa and I were just at a conference together that because Susan was at Hong Kong, she couldn't attend, but she listened in to the whole thing. So we tend to get to know one another. I will also add, it's not a closed community. It's an open community.
We
new members.
Yes.
That's great. Well, hopefully some people will read your book and be like, I want to do this too. And as far as the new approach that you wanted this book to take, or that Aspen encouraged you to take with the book, how is it different from other wills, trusts, and estates casebooks?
I think the In Focus series as a whole is designed to be very user-friendly and accessible to a wide range of students. I think sometimes in law school, there's textbooks, there's a temptation to be very academic, and I think that has its place in a number of courses. And I think for a course like Trust and Estates, a focus on, the nuts and bolts of what am I going to need to practice law, more of an emphasis on what am I going to use and what are the foundational aspects is helpful to students who, may be finding themselves in a general practice, small or solo practice where they're covering a wide range of things, or, breaking into will drafting. I think it is more practical and accessible than some of the other lines of casebooks out there.
So, for example, when there are plenty of cases and there are plenty of problems, the way that the book is set up, there is, before students read a case, there is a case preview. And this is actually in the casebook. It is not in the teacher's manual. material. And so the case preview asks the students to consider a variety of questions as they read the case to help them focus as they read the case. They then read the case, and then after the case, the book is set up with post-case follow-up, which places the case into a larger context in the law. And then, bringing it back to more practice-oriented, there are real-life application questions that follow each case as a way of helping students. One of the skills that we all hope we're teaching students is how to apply the law that they're reading to diverse sets of facts. And so the real-life applications that follow the cases are designed to help students say, okay, I read about a particular doctrine in this case. I saw how it applied to the facts in that case, but now here are a series of different examples that I can think about how the doctrine that was addressed in the case, how that actually applies in these different situations. I can keep going and describe that there are also more features. There's also at the end of the chapter, there are a series of, there's a chapter summary that's brief, but that tries to go over all of the major points in the chapter. And then there are two different sets of questions. There's a set of questions called applying the concepts, and that is exactly what you'd think, applying the concepts. And then after that, there are a series of questions trying to have students, in this case, it's trust and estates in practice, and it's having students think about how the doctrines in the casebook, how they're translated into case law in the particular state, as well as how those issues might be approached in real life legal practice. So designed to put students into practice as well as to become familiar with our state laws.
That sounds like an approach that today's student would really enjoy. A lot of interactivity and some self-paced learning. And it also sounds quite a bit like what I'm hearing from the NextGen Bar. So can you share how this casebook and its approach could lend itself to preparing students for the NextGen Bar?
Sure. I mean, when we originally drafted the casebook, it was with the bar exam in mind, knowing that a trust and estates was susceptible to testing on the multi-state essay examination. With that being phased out with the NextGen Bar, we deliberately changed the focus of the book to still have an ability to help promote the skills that students need to pass the bar. So you've correctly observed that a lot of what they're doing in these applying the concepts problems and in practice problems are what the bar exam now calls foundational skills, where they need to be comfortable not just with legal analysis and determining the probable outcomes of a case, but predicting arguments and counter arguments and weighing the strengths of a claim and drawing out alternative arguments. So in this edition, we've tailored the language in the questions to be similar to what students would see on the NextGen Bar exam, where instead of emphasizing simply the substance of what they're learning, really getting into the style and formula and method of prompting for the skills that they would expect to see on the bar exam.
And so one of the changes in the two, I know you're going to ask us about this, but one of the changes in the editions is for the first edition, trust and estates was one of those topics that was on the bar exam in all states. So one of the changes, of course, is, as you've already mentioned, we are now in a next-gen world. And so even though trusts and estates is not officially on the next-gen bar exam, we're teaching skills, we hope, in the way that we have formed the questions, in the types of applying facts to applying concepts to particular sets of facts. We're hoping that those are exactly the kinds of skills that are tested on the next-gen bar exam.
I think it's certainly the skills that are going to be tested. And hey, you never know, right? Family law wasn't on and now it's back. And maybe you guys will lobby hard enough that wills, trusts, and estates will be on there too. But the skills will be so transferable. So that's really good to hear. Now, the name of the book is Wills, Trusts, and Estates in Focus. And again, it's the second edition. One thing that I know people may be wondering is, here at least, we teach one course that's wills, trusts, and estates, but we teach another course that's wills and trusts. So how suitable is this book for either or both of those courses?
Oh, we're co-authors of a casebook. So go ahead, Alyssa.
Well, I mean, I suppose it depends on what you mean by a wills and trusts course. So, I would say it's a good textbook for any of the entry level foundational trust and estates concepts. But we have an estate planning course and an estate and gift tax course. So, I think that if it's a class that's more targeted toward high net worth tax planning, we have an introductory chapter that will give the foundational concepts of tax law, but I would not use it for a tax centered course.
It is, I am hoping to teach, I have taught trust and estates as a 4-credit course. I do think that if it's a 3 or 4-credit trusts and estates or trusts, wills and estates class, that it can be used for that. But as Alyssa says, right, if you are going to be teaching advanced tax planning, or yes, we have probate administration, another possible thing. Yes, we do have a chapter on probate administration, but for the higher level kind of trust and estates class, course 3, then this is well suited to any basic trusts and estates and wills class.
Terrific. And so regardless of whether it's 3 or 4 hours, this book is well suited. And can you describe for us some of the things that are different in the second edition?
In addition to the changes related to progressing to the NextGen Bar Exam, it's been exciting to see trust and estates actually grow a little bit. I think dead law is a little slow to progress compared to some areas of law. So I think in response to the COVID pandemic, it's been interesting to see a little bit of a jump start to some evolution of law in topics like electronic wills and remote attestation, remote witnessing, remote notary statutes. So I think some of the changes in the law coming out of pandemic are reflected in the text.
There's also been some changes to tax, not major. The new edition addresses, and we did, in a very concentrated manner, go through the questions in the textbook to try to focus on, as we've already said, skills, and to have them even more focused on skills that would be useful for students preparing for the NextGen Bar Exam. We're also relieved that many states are going to continue to test trust and estates in their state's part of the bar exam. And so, of course, the concepts that we're teaching are going to be useful for that as well.
Terrific. I hadn't thought about remote attestation and remote witnessing. That's very interesting. Notarizing. What other topics is the wills, trusts, and estates community kind of grappling with when it comes to future planning for our assets upon death?
While we've reported on some updates in some of the Uniform Law Commission projects, there have been committees relating to conflicts of law in trust and estates, where there is both a restatement, any uniform laws provision. Several other the uniform statutes have also gone through adaptations. Uniform Determination of Death Act, there was a project to revise that ended in not revising it due to too much controversy. I see updates to many of the uniform laws is one thing I'd mention.
And I'll just mention Uniform Determination of Death Act is relevant because you have to know if somebody has survived in order to figure out if they are entitled to inherit, at least as a basic issue. And so determination of death comes in. I often say to students that I could teach so many other areas of the law in trust and estates. And right there's health law coming in. Another development is planning for incapacity. And so as the field of trust and estates has changed, its elder law remains a distinct course, remains a distinct set of issues, but part of estate planning also involves planning for incapacity. And so, of course, trusts are relevant to that, but who's going to have authority to change a will if someone is incapacitated? And so particularly with the aging of the population, this has become an incredibly significant topic within the trusts and estates field. That's one of the changes.
You bring up a good point of the population aging so much longer. I mean, people are generally living now into their 80s and 90s, and some even further than that. And they might outlive all of their descendants or the people they had in their will. So that's That's another issue.
Another actually change in the law is I also teach family law, but family law is quite related. You have to know if you're leaving property to a spouse, who qualifies as a spouse? If you're leaving property to a child or to descendants, who are the individual's legal descendants? And so family law is changing, and that's another change that is reflected in this newer edition of the casebook is changes within family law.
So when you first got together as co-authors, how did you decide how to divide up the process of co-authoring the first edition of Wills, Trusts, and Estates in Focus?
Well, in the first version, we wanted to split it roughly in thirds. And so we started with for the first draft and started with a basic list of the chapters we wanted to cover. And, there were some that we were each very naturally drawn to. Naomi is extremely fluent in family law. So for her to take the chapters that were most directly related to that made a lot of sense. I've got a real soft spot for tax. So I wanted to leap on that one. And Susan has written prolifically about trusts. So she covers many of the trust chapters. So we started by allocating the chapters among us. And then it's been, I think, great for just the experience, but also for the final product that each of us had a hand in all of the chapters, that we each had one that where we would do the first draft, but then it would go through both of the other co-authors for revisions before we considered it to be final. So I really think it has benefited from going through the wash where we have a good start, but then input from other minds to make it as good as it can be.
It's been really important to have a trust relationship because when you share your work product and you say, okay, this will be going out under all three of our names, you have to trust that the other two people are going to respect your work product and then work to improve it. And it truly has been collaborative. In that first edition, we had a primary second reader, but all three of us wound up looking at all of the chapters. So it's a lot more work, I think, in some ways than doing it on your own because you have to do your own chapters and then you have to look at all of the chapters and then incorporate the changes in your chapter, and then it becomes an iterative process because you also want to make sure that the whole book feels unified in its approach, and so you need to work together on that. It's also been one of the benefits of working with Susan and Alyssa is that we've all gotten to know each other better, and so that's also been a lovely part of the co-authorship.
I agree.
If you have any listeners to the episode who are thinking about, well, I wonder if I should co-author, or I wonder if I should write a book in the In Focus series, what sort of advice would you give them?
I would say on the In Focus, I would say go for both of those. For the In Focus, it really the process of analyzing the cases, of setting up the cases with the preview and with the follow-up and the questions really helps you focus on what it is you want students to get from a case. It improves pedagogy as well because you need to think so critically. And although there is more or less a formula, I think it should be a really student-friendly formula. Alyssa's been teaching from the book and so can talk to that part, and then I'll come back to the co-authorship.
I think that's true. And I'd say one of the benefits of writing this textbook, if someone were to consider, taking on a project themselves, is it has absolutely changed the way that I interact with the course and think about the course, and just have a depth of appreciation for what you're doing that just goes beyond what you can get by reading something somebody else wrote. So I hope it has made me a better professor. And I think that that's a common goal for a lot of us who really care about our students.
In terms of the co-authorship, there are a couple of things to consider. I think the advice I had when I was untenured was be careful about co-authoring. And so it's a question of the norms of your institution as to whether you should be co-authoring as your primary way of getting tenure. And it's a very individual decision, and it varies by school as well. For some people, it works out beautifully. Other people might be told, get tenure before you start to co-author. I'll just say that now that I am tenured, co-authoring is such a rich and collaborative way to proceed. Again, you need to make sure that you are co-authoring with people you trust and people whose writing and whose work you respect. You don't have to be similar in many ways, but that foundation of respect is so important because you have to hold on to that as you are reviewing each other's drafts. And there are also different ways. I've worked on other projects. I've worked on some projects where you kind of send out a very rough draft and say, okay, let's figure out where we go. And I've worked on other projects where you send out, not on this book, I'm talking about it more generally, where you send out a very polished draft and you say, if you have any relatively small comments, please go ahead. But it's a question of shared expectations as well. And so establishing how you're going to proceed very early on in the process is going to save a lot of complexity later on.
That's some great advice. How has the student reaction been to your book? I mean, I know the second edition is just freshly out, but you've been using the first edition for a while, I assume. And so what sorts of reactions do you get from students?
Well, I'll often have them remark in teaching evaluations that they're happy with how straightforward the book is. There's no attempt to hide the ball. It is as explicit as it can be. And I think students have reacted well to that.
I think it's also, there's so much to teach in trusts and estates. I've already mentioned 4 credit. It should, of course, everybody thinks their course should be at least 4 credits, if not 6 credits. But I think that the book makes trusts and estates more manageable in a 3 or 4 credit course with its approach. And so, although it covers all the topics in detail, it does so in, I think, a more compact form than do other case books. I'm just holding it. And yeah, the whole book, including with the index, is under 600 pages.
Okay.
So
That's spicy lawyer.
it is case book.
Yes. Well, that's terrific. Well, congratulations on the second edition of Wills, Trusts, and Estates in Focus. And please convey my congratulations to Susan Gary as well. Before we conclude, I'd like to ask you what I ask all of my guests, as you both know, because I've asked you in a prior episode each. I wonder if your answers will have changed. I'll have to check back. What are your predictions for the future of legal education in the coming decade? Why don't we start with Alyssa?
Well, I'll tailor it with being specific to trusts and estates to start. And I will say that I do have a high level of concern with trusts and estates rotating off of bar exams and transitioning to next gen at the same time that we're seeing an increased need for services for seniors. I think it is a policy disconnect to be pulling back on training lawyers to plan for the silver years and beyond, right at the same time that we've got the baby boomer generation not just in need of estate planning services and planning for incapacity, but the retirement of many of the lawyers in that generation who have traditionally been doing this kind of work. So I hope I'm wrong, but my prediction is that over the next decade, we will not have enough lawyers who have been well trained in trusts and estates to serve the community in that capacity. I think the existence of T&E on the bar exam has provided a powerful incentive for students to take a course that they might otherwise not. I think of trust and estates as one of those sleeper courses where every year students go into it taking it because they have to or they feel they have to, and then they fall in love with it. But you don't think you're going to fall in love with dead law because it's dead law, right? So I think that incentive to get people into the area has been important. And I hope I'm overestimating its importance because I really do believe that helping people plan for death and manage estates in the wake of the loss of a loved one is one of the most important things a lawyer can do to help people. So that's where I'm thinking.
Specifically with respect to trusts and estates, I think one of the things that students don't necessarily realize is that you can practice trusts and estates in solo practice or as part of a large law firm, what are now called private wealth groups. And so I agree that students don't seem to realize the range of possible settings in which trust and estates law can be practiced. And so we'll have even fewer of them to whom we can send out that message. We are starting to see some of the changes in trusts and estates that mirror changes more broadly in legal education involve something we talked about earlier, the use of electronic wills. I mean, radical, revolutionary in trusts and estates. We're also we're grappling with the impact of AI. And I was just talking to a practitioner who's writing a chapter about AI and trusts and estates. And law schools are thinking about how to harness AI in our teaching and in everything from LRW classes to thinking about how to harness it in trust and estates. So that's, of course, that's a trend that I think all of us are seeing. So, yeah.
Well, thank you both so much for sharing with us information about your second edition of Wills, Trusts, and Estates in Focus through Aspen. I've enjoyed our conversation, and if you did too, I hope you will listen to additional episodes with legal education thought leaders on Aspen Leading Edge. You can find more episodes on the Aspen Leading Edge webpage or on your favorite podcast channels. Thank you.
It's been wonderful to talk with you. Thank you.